Beloved Creator of all that is, beloved and only Prime Creator, there is a feeling of an intensity of everything at this time. It's a palpable yet etheric pressure that feels like a roiling to the surface, everything surfacing to be seen and felt. When seen and felt, it must be dealt with, like clearing the debris of a flood and building a fresh start post-devastation. Is the experiencing of the devastation the place where we have but one to call on for help? Is it the Deva station, the Deva state, where we call for God's help amid the turmoil, waste and ruin, or peril and overwhelm? These words define themselves. So we feel the intensity, and then we intend. But just who is it that is doing the intending and setting the intention? Isn't this the place where we just feel like throwing up our hands in the immensity of the moment and turn to God, Creator, all that within, to strengthen us, fortify us, and reassure us that we are not alone in our despair and trial of the present? Isn't it at this point that we set our intention out of intensity? And then whose intention is it? I say it is our God self, that part and particle of us that is the Creator, that knows there is really no reliance on anyone but ourself, the powerful self-cognition, where we summon our inner strength and knowingness of our oneness. We walk and move as the body of God in dauntless hope, strength, love, and humility. And so it is.
Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. I got a call this morning from a nice lady in Arkansas. Phyllis referred her. She's not a member of an assembly, but she is just distraught on what she's finding when dealing with Arkansas. And so she reached out and she found out about assemblies, and she's talked to the one on Arkansas, and she's talked to Phyllis, and Phyllis sent her to us, me in particular, representing orsja.org. So this lady wants to force prosecutorial demands upon prosecutors in Arkansas. And that's exactly where I was with Oregon several years ago. I had all of this information, and I had joined the private attorney generals across America and spent hours and hours and hours doing all of that. And we thought we could use the private attorney general to force prosecutors to do their job and to do the right thing. And I still think that's possible in certain conditions, not all of them. So when you're looking at how do you resolve the problem of prosecutorial discretion, I'll tell you what we did on Oregon. Because I talked to two ladies, pardon me. I talked to two ladies today in Arkansas, and they have so much information. Both of them have dropped out of National Liberty Alliance and are really searching for a proper way to get this job done. And they both think that because we've done a whole bunch of things on Oregon that we have the answers to their problems. But it's thought out and it has to be done in a specific order, we think. The reason we think that is it took us 4.5 years to do it. And during that time, we've gotten no rebuttal. The FBI hasn't come knocking on our door. And we've been able to fight in several courts. We've been able to contest in several courts. And they don't like it, but we have standing. And several of their courts have recognized that, and they don't want anything to do with dealing with us. There is a de facto and there is a de jure. But people don't know the real difference between the two and how to put it together to make it work. So this is the first one we think you have to do. Article 1, Section 1 of the Oregon Bill of Rights. We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and that all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times the right to alter, reform, or abolish the government in such manner as they may think proper. So that you have to do. Now, the first thing that comes up is, well, how do you form and declare a social compact? Well, we figured it out and how to do it for Oregon. And when you read the United States of America's Constitution, circa 1859, there's only one Constitution. The Constitution of the United States of America that is in effect now in a de jure form is 1859. That's when Oregon became a state among the several states, and before South Carolina left the perpetual union in 1860. During that stretch, the last stretch of government, the United States of America's Constitution, the first law of the land among all the several states and territories, is that Constitution that we are beneficiaries of. All that changed in March 1861, and we got martial law. And we got martial law thanks to Lincoln, and the entire situation between the North and the South that was resolved. I think it was an Appomattox with an armistice between Grant and Lee. But they never reconstituted the Congress assembled as the United States of America constitutionally. They kept running under the Constitution and the laws of the Lincoln administration and just transferred that Lincoln administration into the next guy's administration and into Grant's administration and all the way to Donald John Trump. They've been transferring a color of law, de facto United States, and there has been no the United States of America and Congress assembled, the creator of the United States in the de jure or the de facto form. There hasn't been one of those in a really long time. That's because it's been martial law everywhere, but it's been a benevolent form of martial law. You hardly knew it was. You knew things weren't right, but you couldn't quite put your finger on it. It was bothersome. At least it was to me. It took me a long time to cure myself of cognitive dissonance. Pardon me. I was American. The judge would say to me, "Are you a U.S. citizen?" I damn straight. Stand up with my shoulders back. Yes. I didn't find out about the deception until 2013, 2014. I started taking action. I couldn't believe it. My friends would say to me stuff, and I would say to them, "Nah, it's not that bad. It's not what you think." And I would make excuses for. But it's hard to make excuses when you see the Twin Towers fall down and then Building 7 fall down, and you say, "Wait a minute now." Airplanes didn't do that. It's just another lie. Back up, Ron. On the point. I got a call, and the call is, I want to know exactly what's the next step that I have to do for my assembly to have a grand jury and to do all the things that you've done on Oregon so that we can begin to clean up the situation that we have on Arkansas. That's reasonable. I don't have that information. The information for every state and territory is going to be slightly different, and each one of the assemblies in each one of the states and commonwealths and territory has to really know what it is that they're doing to flip from the de facto that they have back into the de jure, where they are the de jure form of government and not just some other de facto that can be accused of doing brain lock. uh, Something illegal action won't come. Specific word. In any case, you have to understand on your state or territory when it happened. On Oregon, we know it was November 8th, 1910. It's locked down. It's incontrovertible. I don't know what it is for California, and I don't know what it is for South Carolina. But each one of them has a specific time other than March 1861 on the federal side. They have one on the state side for their state. When did their state flip from de jure into de facto? When did the illegal and illegitimate form of governance take over on your state or territory? When I was in PAG, we had somebody come on with the documents and they showed it on screen and everything, and it was old letters of what happened. And the history goes, in 1906, the Illinois State Bar sent out emissaries to all of the states to flip the states from their de jure form of government into a de facto form of government where they were a subdivision of the United States, Inc. of Washington District of Columbia. 1906. That's when that was supposed to have happened, started by Illinois bar. Whether that's true or not, I don't know. But they flipped Oregon November 8th, 1910. So that part jibes. Then on Oregon became a state in 1859. But the two histories of Oregon, starting in 1848 in one volume and going to 1865 in the first one, and the other one started in 1861 and went to 1876, whatever. But in both volumes, it says there is no Article 13, Anti-Titles of Nobility Act. He writes that in the official history of Oregon. When they got the statehood documents back from Washington, and they were actually a state, no longer a territory, and no longer an independent nation, but now a nation that was independent within the United States of America's several states. Those are all status. So that group that was in control of Oregon at the time of the conflagration between the North and the South, that group that brought forth counties named Grant and Sherman and Crook and all of these guys that were on the federal side got counties named after them. And who knows how deeply that goes. But for instance, on Oregon, Sherman County is a really small county. And a father and son has been sheriff there for together 75 years, I believe it is. So they really know what's going on in Sherman County. And Sherman was a general for the North. So there's been a history of federalism on Oregon. And we know Oregon flipped in November. Well, we found on Oregon that the way to go for this, to return Oregon to a constitutional Republican form of government, a actual nation state in the de jure status and law form, was to use their documents that they provided us, such as this one. You know, to use that document and the other documents to wind our way through this morass to figure out what they had done to us and to undo it and to get to a de jure form of government. And we got there. It took us 4.5 years. It only takes 30 days for any other state and territory to do the paperwork. And when you get the paperwork completed, then you can do all of the other things. But the paperwork can all be completed in 30 days. Doesn't cost that much money. And the paperwork will be slightly different for each and every one of the assemblies that do it. On Oregon, we decided that the ones we were going to notify of what we were doing, and by their acquiescence, it will become a fact, was the U.S. DOJ, U.S. Marshal Services, the FBI, and the U.S. Marine Corps. And on Oregon, we chose the state of Oregon, aka all cap state of Oregon, the executive, legislative, and judiciary. 38 prosecutors, and 36 sheriffs. Those are the ones that we notified of everything we were doing. And by their acquiescence, we secured it in fact. Living testimony in the form of an affidavit of truth signed by the one testifying and with two witnesses filed into a court of record. You have the strongest document you can provide. That's as good as people can do. And that's what we are. We're people. We're not persons. So each state has a little bit different area to deal with. But it can still all be done in 30 days because the people that are actually going to do the work on a state or territory, oh, my dog came to say hello. So the people that decide to do that work, they will know about the date when they flipped Illinois or Kentucky or wherever it was. They'll know those things. They'll know the history of their state and they'll be aware. They'll know who to notify. They'll know who the agent in charge for the FBI is, and they'll know what person to contact within the Marshal Service. They'll know all of these things to execute the plan. But the plan will be slightly different for everybody. So, with full faith and credit, when you read the Constitution, it says all power is inherent in the people. Therefore, if Article 1, Section 1 is not in your state's constitution and you're in a territory from Nevada on is territory, then with full faith and credit, you will have Article 1, Section 1 at your disposal because all of us on Oregon can't have anything that is denied you. So you have all that we have. You just have to figure out the times, the dates, and the places. Now, grand jury, you have to have the ability to put together a jury of peers. That's needed. We're operating on a bell curve where 15, 12% of the population is too ignorant, too stupid to be able to pass the entrance exams to join the military. 62.5% of the population don't care. They're interested in beer, football, and how to make a house square, plumb, and level and get their kids through school and make sure their spouse is happy with them and maybe have enough money for vacation. 62.5. Then we got 16% of the population that's actually smart enough and capable of taking action, but they won't. They'll look at the issue and want somebody else to do it for them, and they won't take action. I have a lot of friends like that. Then there's 3 to 5% that manipulate the good and 3 to 5% that manipulate the bad. We're over here trying our very best and succeeding for over 6 years now with fighting evil from our point of view. And our point of view has not been rebutted by anybody on the left or on the right. So you got to kind of believe that whatever we're doing it pretty close to correct. Cynthia and Brandon stood up to the number 2 man at the Department of Corrections in front of their in front of their building and told the number 2 man by prepared script what the word from our court was. And he accepted that, and he accepted the paperwork. We will have a de jure form of government where a proper oath to the proper constitutions, and we know which ones are proper, to proper constitutions with the laws of nature and nature's God included. That will be the oath. If you can't put together that oath in front of a court and publish it, just like ORS 206 says, there are requirements to be sheriff, and fulfill those requirements, you cannot occupy the seat. Enforcement's not necessary. If 4 people in a court go talk to the sheriff in Washington County and he says, I'm not going to talk to you guys. I'm very happy with the oligarchy out of Salem. Go away. Well, you come back with 8 or 50 or 100. We will have it. Enforcement's not the problem. They will take a proper oath. It's all written down. We know exactly what to do and how to do it. It's inevitable. The pendulum swings. No way out. So please contact us at www.orsja.org or contact me, Ron Vroman, 38 at gmail.com. I have a landline that I borrow, 503-641-8375. Call me, I'll talk to you. We have to get a quorum of the 33 states together. That includes South Carolina, to reconstitute a constitutional Republican form of government and to fulfill the requirements needed to do the job. It's not hard. 30 days. And I yield.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. And then he jumps out of the car. And he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.